Please.
Yes, so my reason for supporting this initiative is very simple: to get it out of the hands of kids. You want marijuana today? Go to a high school. What the bishop just said, you smell it everywhere, you smell it coming out of church. Yes, and it's very easy for kids to get it because drug dealers don't ask for ID. If we can legalize this, we can prevent the high schools from being the place that it's easiest to get the drug. Furthermore, I beg to differ with the statistics quoted by Bishop Allen. According to data from the Colorado court system, marijuana possession arrests have dropped 84% since 2010. In 2010, 9,000 people were arrested for marijuana possession. Using the same data, we are now projecting 1,464 possession arrests for 2014. Furthermore, according to data released by the city of Denver, violent crime and property crime in Denver decreased in 2014. Violent crime in Denver went down by 2.2%, and in the same period, burglaries in Denver decreased by 9.5%, and overall property crime decreased by 8.9%. Now, I'm not saying that's going to happen in California, but there is no evidence that crime goes up. And I think that we've heard a lot of misinformation here. Now, there's a major disagreement between Mr. Lovell and how he sees the initiative in terms of allowing people who are selling huge amounts of illegal drugs coming in, and Mr. Matich, and also the ledge analysts. Mr. Chair, would it be okay if we tried to get an interpretation from the ledge analyst or Mr. Matich up here?
Yeah, let me, before we move on to that, okay, ask if there's any questions specifically for any
Sure.
of these panelists from members of the dais, and then we will go ahead and bring them up, if that's okay, Mr. Quirk.
One question, if
Mr. Hill,
Mr. Chair. Thank
please.
you. Mr. Rundle, you raised the issue of home invasions and the increase in the number of homicides and crimes that were related to drugs. Do you feel that that those are based on the fact that drugs or marijuana today is illegal, or do you see that that would continue if it were legalized? Because as we look at alcohol, I mean, certainly alcohol is related and the cause of crime and homicides elsewhere, but not necessarily for the same reasons. And I guess that's the question that I'm asking. Do you think that that would still continue? Because we don't see that type of crime for alcohol-related or an alcohol-related use.
The officers that I've spoken to throughout the state anticipate that there's a very good likelihood that it would continue based off the more frequent availability of it, its permeation into the black market and other things, but they anticipate that it's very likely that it would continue. Most officers that I've talked to said, we don't like to use the word absolute, but we're pretty certain that it would continue.
Excuse me for interrupting you. They're saying that because even when it's legalized for recreational use and for use that people will still come in and steal your 6 plants perhaps, or you come in and try to take, I mean, we don't see home distilleries any longer, or people, trying to do that with alcohol, but you feel that they would still continue with drugs, or with marijuana.
That's from what I've talked to folks, yeah.
All right, thank you.
Thank you. Let me ask if there's additional questions from members on the dais. Hearing and seeing none, let me thank the panelists. Thank you for your testimony. Dismiss this panel, and then let's go ahead and move to Mr. Quirk. If we could have the LAO and perhaps Mr. Matich, if you'd like to come in and address Mr. Quirk's question.
And while they're coming up, again, officers here may feel crime will increase, but that's not the evidence from Colorado. Thank you.
Yes, we have to. Wait a minute. If he gets to stay, I'm staying.
So if Mr. Edwards or Mr. Matich would like to respond to Mr. Quirk's direct question, we'd appreciate that. Thank you.
Thank you, Mr. Chair. where to begin. I begin with some statements that were made with respect to the grounds for obtaining a license. Representations were made that heroin dealers could get a license under the AUMA. That is simply not true. In order to believe that, one would have to believe that Lori Ajax, the head of the Bureau, would knowingly give a license to somebody who is a heroin dealer. That is not true. The initiative simply says that a prior for certain drug-related offenses is not automatically disqualifying. If somebody is engaged in trafficking white China heroin or cocaine or whatever the case may be, you can bet that they're engaged in other unlawful activities, tax evasion. And what we definitely know is they're engaged in unlicensed sales of controlled substances. And so the conviction, the penal conviction, may not be automatically disqualified. But those other offenses are absolutely grounds that the administrative agency could deny a license on. So it's simply this concern about heroin dealers getting licenses with respect is just simply not true.
Thank you. Let me ask, Mr. Quirk, did you want to follow up on that, or is that sufficient for you? Go ahead.
Perhaps I could ask Mr. Matich to continue with the other points, have the ledge analyst weigh in as he would like, and then I'm sure Mr. Lovell will have something to say.
So, I mean, I think this is really sort of a legal question. Probably best for you to consult with ledge counsel on it. That said, I do think that the language here is pretty clear that these conviction for these specific trafficking offenses is not enough to be the sole condition for denial. So I think it does seem pretty clear that the license application could be denied for other reasons, and that it wouldn't be sort of looked at in favor for the applicant. But again, I think probably best to consult with ledge counsel on that.
All right, and then Mr. Matich, I think, had a couple of other points. We could hear those. And
yeah,
then
if you
hear
have a
from
couple
Mr.
more
Lovell.
points, I know Mr. Hill also has a follow-up question on this line of questioning as well.
It's just related to that, where I'm looking at the statute and it says the licensing authority may deny, and you're saying that they wouldn't grant an application if someone were had been convicted of selling or doing. But I mean, why didn't it say that clearly in the initiative?
Well, I think, again, we were trying to strike a careful balance between ensuring that the regulators had the discretion. And here, there's no question this provision gives the regulators the discretion to deny the license.
Well, do you think they would ever, under any circumstance, grant someone that application? And
what we wanted to do was, in a similar way to what was done in the medical legislation, give the regulators the ability to find that somebody has been rehabilitated. It is true we did not do it the exact same way, but the end result is no different. The regulators have the flexibility to look at a prior offense and determine whether or not somebody is sufficiently rehabilitated to have a license. And if they don't conclude that that's the case, they are not required to get a license. Nobody's entitled to a license.
Got it. So my understanding is under 26057 may, we're really disputing whether it's a may or a shall. Proponents are saying that they won't do it, but the language doesn't say shall, it says may.
Exactly. I mean,
They are empowered.
discretion is there, certainly, but you're adding a lot of conditions in that they would not, or if someone's rehabilitated, that are certainly not in the initiative. So that.
Got it. And let me
Thank
move
you.
to Mr. Lackey has a follow-up question on this line of questioning, I hope.
Yes, it is along this line. If that was the intention, why didn't they just say marijuana felonies and not controlled substance? Because that is very clear to me that there's an intention other than marijuana. And lastly, is there any precedent like this for any other state licensing?
Mr. Lackey, John Lovell, to comment to your question. The San Diego District Attorney's Office, who's not taken a position on the AUMA, has done an extensive analysis of this measure, and they concluded dead on flat that this language prohibits the regulatory agency from denying a license based solely on the conviction. So I come into the regulatory agency and say, I have a conviction for heroin dealing. I've done everything else right. You cannot deny me the license. That's very simple. The language is shall not be considered. Contrast with the medical marijuana bills that I know you were a co-author of last year, and the language is different. The language says you are subject to disqualification. So there is that discretion there that doesn't exist here. And though you had to show certificate of rehabilitation, expungement, stuff like that, it was a rational approach. This is a carve-out for someone who is convicted of trafficking in controlled substances. And as you correctly point out, most of the other ballot measures that deal with this issue have restricted it, all of them, restricted it to prior marijuana convictions. Right. Because under the ballot measure, marijuana will now be legal. But folks, the last time I looked, heroin, cocaine, and meth aren't going to be legal anytime soon, yet you cannot deny someone a license. And this isn't John Lovell, this is San Diego District Attorney. You cannot deny someone a license solely on the basis of that conviction. It's very clear.
Thank you.
All right, thank you. Mr. Lackey, is that sufficient?
I just wanted to hear from the other gentleman.
Please, Mr.
Well, again, I feel like we're spending the time on controlled substance versus the limitations of just marijuana. True enough, it says controlled substance, but we're forgetting that is the sole grounds. The simple existence of that one prior conviction in and of itself is not solely disqualifying. But those types of convictions rarely occur in isolation. Again, if somebody is selling a controlled substance without a license, that is grounds for denial of a license, period. So I think, again, without simply focusing on the term solely is a little limiting, I would say.
I disagree.
All right, thank you. Additional questions for members of the dais. Mr. Quirk, please.
Yes, so Mr. Matich, was there anything else you wanted to bring up in terms of where you and Mr. Lovell might disagree?
Well, I did want to spend a moment, if I may, with respect to the advisory committee. I believe Mr. Lovell referred to it as an opportunity for industry representatives to identify regulations that could be struck down and to essentially help lawyers build their practices. I think if you actually read the text of 2614, you'll see something quite different. First of all, the advisory committee is very similar to the advisory committee under the medical legislation. You want to have an advisory committee. It makes sense to have an advisory committee as these regulatory agencies get up and running. You want to have, as the AUMA does, an advisory committee that helps provide guidance on best practices and guidelines that protect the public health and safety. I'm on page 14. While striking a balance and ensuring that the regulated environment doesn't impose unreasonably impracticable barriers as to perpetuate and reduce and eliminate the illicit market for marijuana. That's the point. We need to have regulations that make sense, that strike the right balance between protecting the public and getting rid of the illicit market. That's what the AMA says the advisory committee is to do. And with respect to this statement that it's going to be stacked with industry representatives, again, I think the plain language speaks for itself. Page 15. The representatives include, it is true, representatives of the marijuana industry, but also representatives of labor organizations, state and local agencies, public health experts, and other subject matter experts, including representatives from the Department of Beverage Control with expertise in regulating commercial adult use intoxicating substances. It's simply not true that the advisory committee is some vehicle for challenging the regulations.
Thank you. The courts might weigh in on that as well. I believe there's a case in North Carolina that touches on this issue, not just with this industry, but many industries. With that, let me go ahead and conclude this because, members, we are now at close to the 4 o'clock mark and we still have public comment. So thank you. Thank you for coming back and answering questions. Appreciate that. Let's go ahead and begin with the public comment section of the hearing. If you could go ahead and state your name and the county you live in, we'd appreciate that. And whether if you could keep your comments brief, please.
My name's Karen Leggett, and I'm from Marysville, California. I wanted to give you some pictures, let you see it. Victims of pot. Peyton Bean, almost killed by her father that was a pot driver. Adrian, killed by a pot driver, and the mother. And these were in different states. I have over 150 stories of children dying from their pot parents, by fires, mauled by dogs, neglect, drownings. It's got to stop. We need to start sending a message to stop relying on pot and other drugs and start relying on ourselves to live. We need to stop that.
Well, thank
And
you.
I
And if
feel
you'd like to
sad.
submit your pictures or anything to the committee, we'd be more than
I
happy
have
to take
done
that as
so,
well.
and I'm going to do again on Friday.
All right. Thank you.
But thank you.
Appreciate it. Thank you for being here. Please.
Yeah, Dale Geringer with California Normal, offices in Oakland and San Francisco and Los Angeles. This is obviously a long and complicated measure, and there are a number of points of confusion and ambiguities that I think need to be cleared up. Let me just mention three quick ones, which I hope either the proponents or the legislature can address. One has to do with the limits on possession of marijuana concentrates. It says everybody adult can have 1 ounce of marijuana or 8 grams of concentrates in section 11362.1, but in two different sections, 11357 ABC and 360, it specifically penalizes 4 grams or more. So do we mean 4 grams or do we mean 8 grams? We need to be clear about that. Secondly, with regard to the DUI provision, the driving provisions, the initiative says that it's legal for adults to possess and transport up to 1 ounce of marijuana, provided it's not in an open container in the car. But there is another provision already in the law that is not struck down in ARMA. Vehicle Code 23222B makes it illegal to drive while in possession of any amount of marijuana. That statute is still on the books. Does this mean that you can transport your marijuana, but you can't drive with it in your car? Can people still be arrested for driving with 1 ounce or less? And thirdly, I'm curious about the clause that bans local governments from prohibiting the legal transport of marijuana, and I wonder whether transport includes delivery, and specifically delivery to medical marijuana patients, and whether it will still be legal for local governments to completely prohibit the delivery of marijuana to qualified patients under the Act. Thank you.
No, thank you for your comments and those questions. Please.
Brian Ortiz on behalf of the American Civil Liberties Union of California. We are in strong support of the Adult Use of Marijuana Act.
Thank you. Additional public comment. Please proceed.
Aziza Davis-Goin. I'm the president and CEO of the Sacramento Black Chamber of Commerce, and we are in support of this act.
Thank you. Please proceed.
My name is Dan Daniels. I'm from the county of Marin. I represent the California State NAACP. We must legalize it. Okay, we've got to put regulations on it. I'm coming from a place of being a parole agent in the city of Oakland. I ran a substance abuse program called SARD, which we tried to regulate people's abuse of drugs. When we had success, it was because we were able to take people away from heroin, it's hard to get people off of crack, but when you can reduce that drug, that's the drug we should be caring about is heroin, okay, not cannabis. I've seen too many people incarcerated over marijuana when it was absolutely needless. And if we don't get it under control, because as it is now, children have access to it. Okay? If you don't realize that, then you need to wake up. Okay? Children right now have access to it. And until we can regulate it and take it out of the hands of children, then we are wasting our time. But I am very much in favor of this initiative.
Thank you. Please.
Asha Harris on behalf of the California State Sheriff's Association in strong opposition.
Thank you.
Rich Miller, Health Education and Legal Patients' Rights. The primary concern for patients across the state, those being medical marijuana patients, is the heavy taxation of taxes. This initiative gives them 15%. In addition to the legislative measures that are currently before both houses, there are taxes. It will make it extremely burdensome for those patients that need access to their medical cannabis. And I'd ask you to consider the taxation structures and relook at it, as there is a clause in ALMA to address this, and to remove some of those taxation on medical cannabis patients. Thank you.
Thank you. Please proceed.
Chairs, respected members of the committee, thank you so much for this opportunity. I live in Yolo County. My name is Hezekiah Allen, and I am here speaking on behalf of the California Growers Association. We are the largest, most diverse, broadest-based association of cannabis business in the state, with 550 members in 48 counties, and I am here to tell you simply that no consensus exists on this measure. The proponents did a fantastic job of outlining the failure of prohibition and the opportunity of regulation. However, with the exception of Ms. Michaels, the opposition failed to capture those voices within our membership that remain opposed to this measure, and I want to just take a moment to celebrate what was achieved last year. Lauren got it right. It was a high point in the national policy conversation regarding cannabis. The consensus that was formed last year of stakeholders in support of the MMRSA represents the best pathway forward. It's a novel regulatory framework that bucks national trends, creates robust protection for small businesses while protecting against consolidation and regulatory capture. It was passed with historic bipartisan support here in this legislature and also in the stakeholder community. The worst thing that this ballot measure has resulted in is a loss of that good faith and that goodwill to work together to solve this problem. It's time to end the prohibition of cannabis. It's a fundamentally failed policy regime. But this is not the best way for California to achieve this outcome. I know it's a long shot, but if you can find it in yourselves to take this one up inside of this legislature, to facilitate, to oversee, and enable the public dialogue that's required to strike a better balance between the multitude of perspectives that are at play here, you could do something tremendously valuable for the state and achieve all of the outcomes outlined by the proponents while avoiding the negative impacts of divisive, all-or-nothing, winner-take-all politics that the electoral process forces upon us. Thank you for the time.
Thank you. Let me ask if there is additional public comment. Hearing and seeing none, let me turn it back to members on the dais for closing remarks. Would any of the chairs like to
Just want to thank the participants. This was a
right,
wonderful
Senator
opportunity. Thank you, Mr. Chair. A wonderful opportunity for us, to, I believe, the legislature and the community to hear from both sides of this important issue. Look forward to seeing what happens in November.
Thank you. Mr. Ridley Thomas, go ahead.
Yes, I'd like to thank the chairs and those who came and offered testimony and public comment. This has caused me to appreciate with greater intentionality some of the challenges that we face in the Los Angeles area with nuisance businesses. And frankly, in the near future, I think, Mr. Chairman, this will require that those who care about such nuisance businesses in Los Angeles take a look at our alcohol beverage control and whatever regulatory scheme comes from this bill and the Medical Marijuana Bureau to make sure that it is appropriately tailored to our concerns. There are state regulatory decisions that will have a negative impact, and they are not fully appreciated, and when they get stuck in regulation, they cannot be corrected, unfortunately. And it's about time that people who represented the area that I come from stood up. There's unfinished work on alcohol beverage control, and my real fear is that we will create a problem in the cannabis space. And I don't think it's unfounded based on our experiences with alcohol. With that, I would again thank you for your partnership and the co-chairs of this hearing and those who attended from the membership as well as those that testified. Thank you, Mr. Chairman.
Thank you. Mr. Wood, please.
Yeah, I'd just like to say thank you to everybody who participated today. I think it was an interesting and robust discussion. I think it will be, as we go forward, I think there will be many more discussions to follow, and ultimately the voters of California will decide is the system that we developed here at the state level where we want to start, or will we move forward with the AUMA, noting that there are some differences. So ultimately, it's up to the voters, and we'll see how this moves forward. So thank you very much.
All right, thank you. Let me go ahead and allow Mr. Gibson an opportunity for a statement.
Thank you very much. I want to thank Chairman Salas and Woods and Ridley Thomas and also Senator Hill for convening such a very important discussion. And I apologize for my tardiness. I was at the State Board of Equalization in support of my bill that was dealing with amnesty for medical marijuana dispensaries in the state of California, Assembly Bill 567. And so it passed unanimously from the State Board of Equalization. I think that this is going to be the law of the land, and we should look at how do we, one, not only tax it, but also how do we regulate it, and also making sure that we have the bells and whistles in place to safeguard, this particular situation being placed in the hands of children, and making sure that our community is in fact protected. I look forward to future dialogues and also voters taking a participatory role in this when it comes before the ballot, and they get a chance to weigh in. So again, thank you very much for the discussion.
Thank you. Assemblymember Quirk, please.
Yeah, so as you may have gathered, I'm in strong support of this measure because I think it is the way to keep marijuana out of the hands of children, which right now it is. And I also believe that it was a reasonably good compromise. And I'm particularly appreciative of all of the discretion that's given to local bodies in terms of deciding when and where and if there should be dispensaries. So with that, I want to thank all the people who were here, particularly the gentleman from the Legislative Analyst Office who had a very difficult job and I think did it extremely well, and from the people who spoke in the various panels, as well as the public comment and others who just came to listen and learn. I know I learned a lot today, so thank you all.
Thank you. Let me go ahead and just conclude out and just say, thank you to all the panelists, proponents, opponents, and everybody that spoke in public comment. I'd also like to thank the staff who put in a lot of time and effort into this hearing. This was an initiative hearing that we must do by statute. And although we weren't able to change any of the language in the initiative, we did get to hear different points of view. And these are points of view we're going to continue to hear out in the public as California voters decide which way the state of California shall move forward on this come November. We do know that Proposition 9 back in 2010 did fail, and I do believe the proponents addressed some of that even in their testimony about how they think they're coming back with a stronger, more robust initiative. But with that, ultimately, it will be up to the voters. And with that, I do want to thank everyone for coming. But just for the record, let me go ahead and announce all the members that were here and that did participate, starting with, obviously, our co-chair, Senator Hill, Assemblymember Wood, Assemblymember Ridley Thomas, I know Assemblymember Quirk, Mr. Gibson, who's still here at the conclusion, Assemblymember Lackey, Chavez, Campos, Jones Sawyer, Eggman, Breaux, Burke, Dodd, Rodriguez, and Senators Bate and Wachowski. And with that, let me go ahead and conclude this hearing. Thank you all for being here.